Hello, sisters. Lesbian Psychologies, Explorations and Challenges, edited by the Boston Lesbian Psychologies Collective. Part 5, Community, Essay 19. Mediation for Lesbians, by Bonnie J. Engelhardt and Katherine Triantafillou. Before we began to work together, we had dealt individually with the legal and emotional ramifications of lesbians separating from each other in painful and often financially debilitating ways. Given today's legal system and the reality of lesbian relationships, we began to see the need for a multidisciplinary approach as we grappled with these problems in professional isolation. What began as a dialogue between us because of our unique relationships to the Boston lesbian community grew into a business relationship called, quote-unquote, gay mediation. We created our mediation service to address a growing need for lesbians and gay men to have an alternative process for resolving disputes. One of us, Engelhardt, a licensed independent clinical social worker, has had 20 years of experience as a social worker/therapist, now specializing in couples counseling and sex therapy in the lesbian and gay community. The other, Triantafillou, is a family law practitioner and civil rights attorney who has represented lesbians facing such legal issues as divorce, custody, buying and selling of houses, starting businesses, and making wills and contracts. We will focus in this chapter on our work over the past decade with lesbian couples and groups. We will present part of this chapter in the form of a dialogue, much as we present it to an audience of psychotherapists at a conference on issues in the psychology of women. We will consider the following questions, the most relevant to understanding the process of mediation between and among lesbians. What is, quote-unquote, lesbian mediation from a psychological and emotional viewpoint? What personality characteristics are helpful for or detrimental to a mediator? What is the process between a therapist and lawyer? Who is responsible for the outcome? Are we equal or two bosses? Our mediation service grew out of the political context of a generally homophobic legal system that pits gay couples and groups against each other in a highly charged, hostile environment. This advocacy system costs a lot in time and resources and potentially jeopardizes people's lives beyond the issue in conflict, such as job loss and custody disputes arising from public acknowledgement of lesbianism. The goal of lesbian mediation is to provide a forum for couples and organizations to define or redefine their relationships, deal with emotional issues involved, and formulate workable legal contracts. All the parties in a dispute agree to 3 to 6 one-on-one half-hour sessions. At the end of this process, the parties sign a contract reflecting the agreements made during the sessions. One of the reasons this process is so important is that courts are unable to deal with conflicts between lesbians without quote-unquote punishing the participants for their homosexuality. Hence, gay people do not generally have access to courts without the attendant fear of being found out. A lesbian mediation service is unique because it provides an additional level of safety for the participants. It also serves as a forum to validate, psychically and socially, the charges that relationships undergo. Because lesbians cannot marry, they cannot divorce institutionally, unlike heterosexual couples who can go into court immediately to redress their relationship grievances in a fairly direct and simple way. A lesbian in conflict must deny her relationship and create a legal action based on something else, for example, home ownership or a landlord-tenant problem. Some gay women have been known to use criminal laws such as conversion or trespassing to deal with disputes over property. Another area of intensity for divorcing lesbians is the issue of child visits between the divorced lesbian and her ex-lover. To attempt to deal with this problem in heterosexual courts is to invite serious legal problems with an ex-husband, not to mention the difficulty of fashioning a complaint. Another example of the unique use of mediation is between groups of lesbians who have formed business relationships with each other. We use quote-unquote business adversely because we have found that the business partnerships that couples and threesomes form usually have highly emotional underpinnings. The collective wishing to provide services at low cost to women is an example of such a partnership, as is the lover/business partner wishing to work in a non-hierarchical atmosphere while providing an alternative service to other lesbians. The problems in these partnerships might be resolved in heterosexual courts, but not without expense and danger. The most publicized example, of course, is Marilyn Bennett's suit against Billie Jean King. Although lesbians approach business and personal relationships with as much romanticism as do heterosexuals, an additional component of the romanticism is political correctness. Hence, groups form not to make money, but to help other women. Problems arise when partners discover intense reactions to differences in class background and race that were not evident in the beginning or the limerence phase of the relationship. Limerence is a word coined by psychologist Dorothy Tanoff in her book Love and Limerence to mean the state of being in love. Mediation before groups organize gives partners a forum to explore possible pitfalls with both a therapist and a lawyer present to challenge and translate romantic notions into working contracts. We must also distinguish mediation from arbitration. Mediation is a voluntary process in which the participants discuss the conflicts or issues between them and arrive at a self-directed solution with the aid of a facilitator. Arbitration involves all parties submitting a claim to an arbiter who hears evidence and renders a decision, much as a judge would do in a court of law. In addition to the actual mediation service, we are also interested in developing models for lesbian feminist lawyers, therapists, and judges to create alternative dispute resolution techniques. Our dialogue begins with an analysis of characteristics of a mediator that have been compiled from our subjective experience as mediators. They should be used as indicators to determine whether a person is likely to enjoy this kind of work and be effective at it. BJE. To me, these are the characteristics most important in enhancing the enjoyment of the role of a mediator. That the person has the ability to do creative contracting, enjoys the role of director, is extroverted and can use humor, strives to be clear and open about her own values, is able to allow others to set rules of fairness, can tolerate intense emotional expression and can create an atmosphere of safety, is able to develop structure but is prepared for spontaneity, is comfortable with quote-unquote wheeling and dealing, is aware of her own blaming behavior, and is able to work in collaboration with another discipline. These 10 characteristics seem essential to our lesbian mediation process. If someone is uncomfortable with many of these criteria, she might consider using arbitration or another form of mediation practice that would allow for more control. Let me go into more detail about these 10 criteria. 1. Creative contracting. Some therapists sign written contracts with their clients concerning the practical aspects of the therapist/client relationship, missed sessions, fee responsibilities, vacations, and so forth. Other professionals look a little blank when one uses the word quote-unquote contracting. I probably enjoyed this mediation process because I came from training and experience in contracting with couples and groups that included contracting on practical issues as well as emotional focuses. For example, quote, "This group will provide a safe place for you to ventilate your feelings if you strive to be completely honest with yourself and us," end quote. Being able to ask pointed questions, quote, "What do you want right now?" end quote, and, quote, "How are you going to get that from her?" end quote, is a useful skill. Liking the give and take of contracting increases the effectiveness of the role. 2. Enjoying the role of director and the process of orchestration. One has to appreciate the balance between directing and controlling, that is, being sure that things are moving in one direction or happening so clearly that everyone can see the orchestration. 3. A degree of extroversion. I can't really find a better word than extroversion here. A true, full extrovert probably cannot be a good mediator because it's not really her show. On the other hand, if one is not able to be a bit extroverted and really get in there, Then the process is slowed down. 4. Being clear about values. There is no way that as mediators, we can keep our values or our biases out of the process, but it is always useful when we own up to our biases with the individuals we are working with, trying to be clear that what's good for us may or may not be good for each person. 5. Being able to let others set up their own rules of fairness. This one is difficult for me, because I usually judge what's fair in terms of my own values. Even though I felt concerned that a couple of contracts were not fair, the subjective experience of the individuals involved was that the contract was fair. That is the goal of mediation as we find it, to arrive at a contract that all parties consider equitable. Sometimes we really have to struggle with our own ideas about fairness, equality, and values that we've inculcated in ourselves or have had as part of our professions. This is not to say we do not interject our opinions of fairness to keep the issue alive. If a client were to say that she felt a particular arrangement was comfortable for her, but I felt she was not getting a good deal, I would be very assertive in trying to get her to defend her view of the contract. For example, we would try to get her to say some more about why she doesn't want half the house. I might say, quote, "What's wrong with the situation so that you don't deserve half?" End quote. This prodding helps to achieve equity. That is a little different from deciding somewhere along the way to stop the process because it doesn't feel fair to us. It's my responsibility to interject my own opinion to help people get their own feelings about what's fair. 6. Not being afraid of anger. That is, allowing anger and rudeness. Some feminists have commented that rudeness is antithetical to feminist theory and female behavior. But if we didn't allow rudeness during the mediation process, we would get nowhere. It is an acceptable form of behavior when you feel finished with your relationship with someone. We have to be semi-comfortable with the idea that people are going to be rude and relatively insensitive to the other person's feelings in the process. Expressing anger, rudeness, or fighting. Many people use the mediation process to end a relationship, which can clearly involve fighting. That doesn't necessarily mean physical fighting, but the situation is often very tense, with a considerable amount of clash. People who have not talked or who have not shared emotional feelings for quite some time are often not willing to do so in the space and time that's allowed in mediation. They are generally not immediately open to the process of sharing hurt feelings with another person they believe has really damaged them. The mediator's responsibility is to help them get out enough emotions in a cathartic way so that they can at least go on with the process. One has to enjoy digging into people's emotions. Some people, including therapists, find this difficult to sustain if the feelings are intense. 7. Being able to develop structure. There are various approaches to the use of structure in therapy and wide differences in the experience of trained therapists. In mediation, we have a minimum of 3.5-hour sessions, and the entire process is very structured. We know some therapists who don't work well with this kind of time constraint. They feel pressure to get things done and see the process as regimented and legalistic. Liking or not liking structure would make a difference in one's decision to be a mediator. However, one must have room for spontaneity. We've never had one mediation that was ever like any other. Unexpected things are always happening, and appropriately so, for change to actually occur. Being comfortable with the quote-unquote wheeling and dealing. Sometimes it feels like a Perry Mason kind of atmosphere, with 3 or 4 people in the room, each with a different agenda, and Katherine and I in the corner, privately conferring about how we get out of this emotional mess, how we get to the facts. There is something in the process that feels a little dramatic, sometimes a little bigger than life. I think lawyers wheel and deal much more often than therapists. Being able to operate in a process way, more openly and more dramatically, was a new experience for me. 9. Being aware of one's blame behavior. being aware of one's own blame behavior. This process can bring out blame behavior in everyone. Katherine and I have had to Catherine and I have to be repeatedly careful not to say to each other, quote, well, things would have been fine if only that person hadn't done that, end quote, or feeling that the need for mediation is the result of one person's bad behavior, rather than understanding that the process of mediation is the focus. 10. Being able to collaborate. Collaboration between a therapist and lawyer requires respect and willingness to use all of each other's skills, not just the ones we feel ourselves to be lacking. We must be both lawyers and therapists in our mediator role, fulfilling and completing all of the process for both. KT. In addition to the characteristics Bonnie mentioned, lawyers should have these characteristics for working as a mediator: a willingness to take risks within the legal community, a belief in establishing a new form of conflict resolution or a distaste for the advocacy system, no fear of feelings or dealing with feelings, their own or others, some experience in therapy themselves, some experience in grassroots feminist groups. Basically, Bonnie and I started mediating because quite often I would get called from both sides of a conflict. 10 years ago, there weren't as many women lawyers in private practice in the Boston area. One lover would call up and I would hear her story and make an appointment. On the next person's call, I would have to say, quote, well, I think I've heard this story before. Hold on, I can't represent you, end quote. As an attorney, I am governed by a quote-unquote conflict of interest rule about representing two sides of the same conflict. Another reality of the legal system is that courts are filled with an enormous amount of negative energy. When I first started practicing, there were very few days when I thought I wouldn't come back from court and cry just because of the psychic battering that both my clients and I was working with battered women at the time, would experience. The third factor that led us to mediation was a commitment to the lesbian feminist community. I wanted to create a new form of conflict resolution that was less damaging to women and more in tune with my political beliefs. In my opinion, there is no such thing as a feminist attorney. I think the words feminist attorney are mutually exclusive. Feminism is a belief system based in part on the efficacy of the quote-unquote feeling process. As a therapist, Bonnie really has a lot more room for creativity in the process. If you are an attorney, you must be an advocate that manipulates, denies, or misnames feelings, when and if they are present. I wanted more from myself and more from the feminist community in the way we solve problems. We don't need more women attorneys thinking, talking, and feeling like men. With that background, I finally called Bonnie and I said I was beginning to feel like a therapist because many of my clients didn't have exclusively legal problems, and their emotional blocks were standing in the way of the decision-making process. People have to cope with enormous feelings in these situations, and they don't know where or how to vent them. No amount of good lawyering was helping, especially in a homophobic legal system. Lawyers are generally not trained to deal with feelings at all. Having been through both singles and couples therapy, I am familiar with the process, and I am comfortable with therapeutic language. I was also very determined at the beginning of my practice to create a holistic environment in which to work and not distance myself from my own feelings. Particularly when I was working with battered women in divorce situations, I would try to get the women to recognize their feelings about the battering in order to mobilize them to undergo the legal process so that they would agree to specific terms in the divorce agreement. Therapists looking for lawyers with whom to do mediation must realize that there is nothing in a lawyer's training that teaches us how to mediate or arbitrate disputes. Lawyers are basically trained to advocate. There is right and wrong depending on who pays you. You know case law, and there is a way and style of talking and being in a courtroom that is very different from what a therapist does. I could not walk into a court and say, quote, well, Your Honor, she needs to rant and rave and process her rage before she'll agree to visitation or do that amount of support, end quote. I must translate the language of the therapeutic process into a context and language that is very concrete. BJE. We do not know any place that is teaching what we do. There is definitely a need for lesbian feminist mediation training. In divorce mediation training, one learns very specific things that are endemic to heterosexual divorce, not something that would necessarily help lesbians. Family therapy training was most useful to me in this experience. It deals with the issues of roles people assume, not blaming one person, but understanding the process and dealing with it. Systems theory, an understanding of how things happen and when and where, and being able to draw maps about how things happen, is also useful. Many times, we have to pull people back to get them to notice how they are feeling and how their position affects what they are saying. They need to be cognitively aware of the differences in power, ability, skill, and access. Sometimes it has been very useful to take people's emotions and put them on a map to show where they stand in relation to each other. Couples and group therapy training have also provided the kind of training that I fell back on in doing mediation. There are some new quote-unquote contracting books that I feel are useful, but they alone are not enough to prepare one to mediate. There is also a need for more lesbian feminist arbitration. We have talked with women from California and New York who are trying to set up arbitration boards that were appropriate for lesbian feminists, taking the role and responsibility for being arbiters. This is an entirely new and exciting development. KT. Another important aspect of the type of mediation we do involves legal and personal issues of money, trust, and responsibility. BJE. Mediation is a co-therapy situation in many ways, but it differs in that Katherine and I represent different disciplines. I think things work well between us because we have a full friend relationship as well as a professional relationship. When Katherine and I have looked at other lawyers or therapists to do the work with, we ran into some difficulty. Working together in this volatile situation, each of us has to have 100% trust that the other is going to do her own job and that I'm going to do 100% of my job plus part of her job as well. There is a real need to be fully there in the hour and a half, fully trusting and respecting the differences between us, our disciplines, and our personalities. You have to work with someone whose work you trust completely because you can't be spending time worrying about your own relationship in the process. There is too much going on. Of course, there are times when Katherine and I disagree. I might say, quote, "Wait a minute, that sounds off the wall," end quote. Or Katherine says to me, quote, "You are really getting into your therapist role," end quote. KT. I don't say it quite that way. It's more like, quote, "Bonnie, lay off, you're being an idiot," end quote. BJE. As in any co-therapy situation, after we leave the first session, we will argue about who the people are, whether we like the way they do things, and whether we think their position is fair. If mediators cannot be brutally honest with each other, they cannot keep the relationship as clean as necessary to be effective. We trust that even though Katherine might hate one of the people in the room, she will not write a good contract for that person. Even though I really might not get along with a person or be able to stand her idea of fairness, I am able to bring out her feelings and help her deal with taking care of herself. I consider myself 100% responsible for the emotional activity of what's going on and 50% responsible for the contract. Katherine considers herself 50% responsible for the emotional work and 100% responsible for the contract. KT. The setting of fees is also one of the difficulties we see as important in this interdisciplinary approach to mediation. Our base rate in 1984 was approximately $400 minimum, which includes the contract and covers the 4.5 hours of time we spend in sessions, as well as some time spent outside the session. BJE. My experience of setting fees as a therapist is different from Katherine's as a lawyer. We had to work out a system that covered the client's needs to have a lawyer and a therapist and still not be so financially out of bounds that they would feel they would be better off hiring 2 lawyers. We struggled with offering a sliding scale fee. For our purposes, we decided to set a fixed amount, making it clear that the amount is sometimes more, sometimes less than what we make in the rest of our work. It has not been cost efficient for us to do mediation. Both of us tend to make half of our usual hourly rate. There have been difficulties, I feel, that Katherine does more work than I do after the sessions end. The therapist shows up for a meeting, emotes, relates, and then goes home. That's when the lawyer starts her work. Katherine writes the contract, she goes through several drafts. She has to be present during all the sessions and then do homework afterwards. KT. We also see money as the big issue in terms of people's willingness and ability to pay. We talk about the fee the first thing, and usually half the money is upfront. A structure concern for me is that I cannot split fees with a non-lawyer, so they pay half to Bonnie and half to me, not both of us. If additional documents have been drafted, such as a deed or a promissory roll, we negotiate the cost when the matter comes up. We also spend a lot of time talking on the telephone to figure out what our feelings are, what they think is fair, and what we think is the next step. BJE. Also, for some people, our price is too high. There are 2 different values at odds with each other for those people who feel that their only next choice is to go to court and spend even more money. If the spectrum of litigation expenses, $200 for each, is not very expensive. KT. Sometimes I'm asked why I got into this work. Unlike the women's health movement, we in the legal profession have tinkered with words, but we have not focused on empowering women. We have not changed the nature of the advocacy system nor the patriarchal concepts underlying that advocacy. I believe the existing models of legal analysis severely limit the non-violent or non-patriarchal resolutions of conflicts. I also believe that the process harms both the female participants and the advocate, and the results do nothing to empower women. The usual legal forum simply doesn't offer the participants any opportunity to discharge feelings constructively and does not allow anyone to reach catharsis. Because resolutions are imposed from an ostensible authority, the judge, the participants, through a go-between, lawyer, never let go of a conflict and rarely take responsibility for their actions. People seldom feel good about the process. The rage that clients often feel toward the wrongdoer is transformed onto the system, the judge, the lawyer, and the costs. BJE. This system also perpetuates the quote-unquote victim mentality and leaves our community cluttered with unresolved relationships. KT. I can always write a contract and to a certain extent get what I want in a contract, but I want my clients to feel better about the process, not abused or manipulated. BJE. I often work with women who are unable to get an agreement about anything. They go through many hours of emotionally draining experiences that result in nothing legally enforceable. It's been very important. It's been a very important, empowering experience to help women feel connected to their quote unquote awful feelings and still realize that the process of mediation was a good one for the relationship, especially when they end with something legally binding and that covers their financial interests, something that they often could not get from standard couples therapy. Clinicians have asked me why limit the process to a fixed number of sessions, no matter what. My experience has been, as with all short-term therapy, that if the participants know how much time they have to deal with the issue, they get organized and deal with it. That philosophy works here. I give myself room several times to say to people, quote, well, we are about a third of the way through. Do you feel like you have done a third of the emotional work? End quote. Or when we are near to the end, to say, quote, we expect that by the end of the second session, everybody is really clear about the wording of this contract, end quote. We do not wait for that until the third session, because in our experience, wording is where all the emotions come together. We have found it is best to have people do their homework, to come back with written words they feel represent them concretely. By the end of the first session, we try to give to each a draft of where we are and what has been accomplished. Declaring in what areas we are in agreement early is helpful, and we try to get them in writing early to feel that we are starting out from agreements. I've learned a lot about creative financing from Katherine, especially the process of rethinking something in terms of how one deals with money and how to translate it into contracts. It was not a part of my training as a therapist, and certainly not for me as a woman in the world, to learn how to refinance things. There are different kinds of legal information that can affect different emotional processes. We've dealt with battering situations as well as with real estate, property, a car, a house. Today, if a couple wants to break up the relationship and they are not speaking to each other, what can they do? We are also dealing with what is really missing in terms of our larger lesbian feminist community and our experience as women: the ability to negotiate for what we want. KT. It is my experience that lesbians are really invested in being politically correct and feeling correct. One example comes to mind. 2 or 3 women who have bought a house with a political ideal of no quote-unquote ownership, no boss. They are buying to give everybody a cheap apartment or a shared living arrangement to have an ideal space to grow. When it gets down to mediation and renegotiation about it, they are still saying these politically correct words and not really getting to, quote, well, I'm really furious because it was my money we used for the down payment, end quote. Or, quote, I pay the taxes, end quote. Or, quote, you did work, but I didn't get such and such, end quote. There are a lot of hidden issues around what is called capital contributions and what goes into buying property. BJE. It's a question of how to value those things we feel very emotional about. Some things of value to lesbian feminists may not be valued by the broader community. Consequently, we need to learn to put a financial value on something for which we want to negotiate. We come to the point of saying, quote unquote, what is your bottom line? Quote, what will make you feel okay? End quote. Women say, quote, oh, I can't do that. That's so arbitrary, end quote. But that's what we're here for. An arbitrary feeling about the world would be all right for you. That can be a new way to think for women concerning their values. We seem to be more stuck on the idea that things have a right or wrong value, or that things have an absolute value, rather than things are valuable to me based on my experience with them. In mediation, we deal with emotions and how to place monetary values and negotiate for ourselves. KT. People will call us when they are interested in mediation, or are referred from another therapist, or present a problem where it seems appropriate to ask if they would be interested in having us mediate. When they say they really don't want to go to court, they really don't want to sue, they just want to get out of the situation and find a solution, I'll present mediation as a possibility. In the very first mediation session, after we define what we are there to do and what we are not there to do, Bonnie is not a couples therapist for them, and I am not a lawyer for either of them. We try to determine what the facts and issues are. What is going on? What property needs to be split up? Also, what additional information do I need to know about the house, the car, whatever? Does the home or car need to be refinanced? Can they get refinancing to buy someone out? Where are the deed and other documents? Bonnie and I usually confer after the first session and try to figure out if we both have the same opinion about what we think the issues are and what we think the hard issues are or are not going to be. Here is the stumbling block, and here's the way to get around this issue. When Bonnie sees something going on with emotional issues, she may want to know if something is possible legally. Is it possible in the spectrum of the world of law as opposed to the world of feeling? The second session is usually when people get the most emotional, the most violent in terms of their feelings. Quote, "No, I am not signing over the house because you get your way all the time." End quote. Quote, "You went off with my best friend, and I'm not going to give you the Holly Mirror records, too." End quote. BJE. That sounds like a joke, but we discovered that often the hardest issues are the smallest ones. Bigger issues had already been discussed. People discuss houses more than clothes, clothes more than records. Record albums have wrecked many a second session. After suggesting buying duplicates, I even came to the point once of going and getting one of my records off the shelf and saying, quote, "Look, this is fine. Now we have two records." End quote. It is so ironic, the small but important issues that people latch onto emotionally. Quote, "This was my record." End quote. Quote, "No, it's not. It's my record, and I'm not leaving this relationship without this record." End quote. It seems the little points are the ones that people get emotionally invested in, and the larger issues have been thought through and ventilated more. I think another important issue that I've discovered in couples therapy, as well as mediation, is that there is a great lack of ability in the lesbian feminist community to know how to negotiate or contract. That's probably true for women in general. I've been impressed by feminists who are very capable of analyzing and understanding why they don't have what they want, but lack the ability to negotiate and stand up for what they do want. This is a level of skill that is generally lacking in our clients. KT. By the third session, I will have drafted the final contract. Everyone gets her own copy. We go over the points that are definitely agreed upon. Bonnie usually keeps lists of what we have and have not agreed on. She is really good with lists. Sometimes I will put alternatives to unresolved questions in different paragraphs using wording reflective of the different points of view. BJE. We arrive by the end of the second session with all of the alternatives we are considering. We may have 6 alternatives, and we would have all 6 of them in writing. Then we can eliminate the ones that are intolerable, ranking them in terms of which can be considered. What else can be changed now? I try to keep in mind the questions anyone has any emotional difficulties about, as well as the ones that are not so dead set upon. Someone might be thinking differently about the issue, so perhaps at the end I may say, quote, "Well, you said you could sort of think about this. Could you just for a minute do that?" End quote. I try to keep in mind how invested people are in the process as we go along, because those last minutes are ticking away. Quote, "Okay, we are halfway through the last session. We have to sign this in 1.5 hours. We must get to what your bottom line is. You must know right now, how do you feel about this? There are no alternatives." End quote. People have to choose among written alternatives in the final draft contract. It's not all right for anyone to come up with new alternatives in the final session, unless that was agreed upon earlier. By the end of the second session, we tried to have in writing all the possible alternatives. Nothing new should happen at the third session. One ought not to start anything new in the termination process of therapy, and if you start something new in the third session of mediation, you've lost it. Then you're into a whole new process. Clients could say, quote, "It's easy, I just want to change this little thing," end quote, and fail to realize that this quote unquote one little thing may have a big impact on the other person and the process. It is because partners have consented to the fixed number of sessions at the beginning that lesbian feminist mediation works. It would not work if we said, quote, "You have to do this because we want you to," end quote. It only works because partners want to finish with the issue in their own lives and because they feel they are getting something for what they are giving up. What ultimately brings lesbians to mediation is the dilemma of having unfinished and unresolved relationships that inhibit them from moving on with their own growth as a person in a relationship or a partner in a business concern. Gaining freedom to remove money, time, and emotional investment is a highly motivating force to complete the mediation process. Resolution occurs most frequently when a lawsuit is the next step, and when the mediation process allows each member to express herself powerfully and personally by the use of quote unquote facts and quote unquote feelings. We don't tell people they need resolution. We offer resolutions to those who don't quite know how to figure out emotionally and practically that they want it. Our model is similar to what would be covered in a conflict resolution workshop because we get agreement from the beginning that the partners are ready to get rid of this problem emotionally. Because most people don't know how to do that, they feel their only alternative is to go to court. We seldom see people who feel that if they just went to therapy, things would be better. They have exhausted all other options when we see them. Most lesbians in our experience would prefer not to go to court, not to have their names in the ledger, not to go through all the stuff that goes along with going to court. This is a good incentive to get a contract that feels fair. KT. If someone gets in touch with me about wanting to sue, I'll try to find out at what stage they are and perhaps send them some information about lesbian mediation. I may ask, quote, "Are you interested in mediating this issue before you tell me too much?" End quote. I don't want to get myself out of the ability, ethically, to mediate the issue. I don't want them to tell me too much too much about the facts, just where they are in the internal process. Someone might say, quote, "I really don't want to sue. I want to know my rights, but I don't want to go to court." End quote. BJE. I do think, though, that in every situation we have seen, the next step would be a lawsuit. We are talking about large amounts of money or property, or about investments in a relationship for a long period of time. So far, none of our clients have ended up in court. I can imagine being in a situation, however, where the process might not work. That involves our definition of success and failure. We have had a situation that we felt was a failure because we didn't like the process. We didn't feel that people were being fair and honest. We did as much as we could and repeatedly struggled with the issue as a group. It just didn't end up feeling good to Katherine and me. Although we might count that as a failure, the participants felt very relieved that they were out of the situation and were not going to have to deal with it in court, and they didn't expect to feel good. I think they felt they were being idealistic and expecting them to feel better. No, I think they felt we were being idealistic in expecting them to feel better. KT. It is important to remember the distinction between mediation and arbitration. Mediation, as we define it, is a process to resolve a property matter or to resolve a relationship. It is a process whereby both people can come to an agreement that is enforceable and that they can live with and that they feel good about. Everybody finishes feeling better about the process. It is less expensive than hiring separate attorneys. It is expected that some emotional catharsis will happen as a result of the process. It is becoming very trendy in the legal system to quote-unquote mediate, and there are a lot of divorce mediation centers or probation departments that offer mediation. I would, however, be very hesitant about letting lesbians go into these mediation centers and court clinics. I think what they call mediation differs very much from what we call mediation, primarily because of the institutionalized power disparity in heterosexual relationships, how they are perceived, and how it is handled by the mediator. Arbitration is just like going to court, except that each person submits a claim to an arbiter who basically acts like a judge who doesn't necessarily apply judicial concepts or legal concepts all the time. Arbiters listen to one side, then listen to the other, and then they render a decision based on their perceptions of fairness. The parties have agreed to be bound by the arbiter's decision. Arbitration is governed by state statutes. There is an Arbitration Act, a National Arbitration Association, and a particular way of resolving disputes according to the rules that are enforced in court. We prefer the mediation model because it allows the participants a vehicle to decathect from a painful situation. It also serves the goal of empowering participants to resolve their problems and learn skills that may be useful to them in the future.